May it please the court, Elliot Shirker on behalf of Halifax Hospital. This is a statutory construction case. The question is whether under the 2003 Enabling Act or under Chapter 163 of Florida statutes, Halifax is empowered to construct and operate a hospital in the City of Deltona. We submit the answer is yes, and that the bonds are therefore valid. Under the Enabling Act, on its face, does not expressly reference extraterritorial operations one way or the other. But for approximately 60 plus years, between 1925 and 1979, Section 5 of the Enabling Act, the original 1925 Enabling Act, did, at least arguably, because it authorized Halifax, quote, to establish, construct, operate, etc., hospitals as, quote, shall be necessary for the use of the people of said district. For the use of the people of said district. That's Appendix 1 at page 257. In the
Let me ask you this. Wouldn't you agree that statutes that are related have to be read together in order to understand them?
Absolutely right.
Okay. And wouldn't you agree that the special law that we're talking about is inextricably related to 189.0126 that authorizes these local governmental special purpose entities?
Well, it's enacted pursuant to Chapter 189, which requires special acts.
And that statute says that those entities generally are to be created with jurisdiction to operate within a limited geographic boundary. That's what that statute says, correct?
Yes, Your Honor.
So it seems to me that if you were going to have a subset of that statute, a special law that creates one of these entities authorized by that law, and it was going to do something different, which I think your client's interpretation is that they can operate a McDonald's in Tokyo as long as it gives them money to operate the hospital here.
Your Honor, that was clearly in jest, but yes, that is in the deposition.
No, but it really is the theory. You say there's no geographic limitation on where you can operate as long as it creates revenue that you can then use to serve your clients.
There's no geographic limitation in which Halifax can establish hospitals and medical facilities for the public good and public health. That's our position. Because Halifax is empowered to establish hospitals. Halifax is a hospital.
Okay, so it could establish a hospital in Tokyo.
Your Honor, I doubt it. The statute governs the state of Florida, and
Pensacola.
I wouldn't say no to that, Your Honor. I wouldn't say no to that, no. Because we currently operate, just as the record shows, in Orange County, in Brevard County, in Flagler County, and outside of our district in Volusia County. As a matter of fact, the emergency room in the City of Deltona at Halifax Crossings is our facility operating now. That's how we've operated since 1979. But all we do is build hospitals and provide care for pain patients and indigent patients. That's what we do. That's who we are. And that's all we're asking the court to allow us to do under a fair reading of the Enabling Act. Now, Justice Lawson, to get back to your question, there's no dispute in this case from anyone that a special act such as ours can authorize a special district to operate extraterritorially. You've basically got 3 or 4 different categories of special acts for these hospital districts. They're all cited in our brief. You have statutes that expressly say you may only operate within the district in so many words. They have statutes that say you may operate outside the district. And most interestingly, there's a whole set of those enabling acts that includes the language that was struck from this statute in 1979 for the people of said district. Those still exist. So the absolute presumption has to be that when that language was removed from our Enabling Act, it had to mean something.
Well, why is that so when similar language is left in there? And because we have this language about for the use of the public of the district. We have the language referring to facilities and services in the district. We have the language that states for the general welfare of the residents of the district. It is a theme in this provision. And I understand your argument, but I think it's a highly technical argument that it is really inconsistent with the context. When we look at it in this context, I'm having trouble accepting it. It requires that we interpret something in the disjunctive, when really it's more natural to interpret it in the conjunctive. But why am I wrong? Because I know you disagree with me. So help me understand why those things, Matt, you're focused on something that's been taken out when there are these things that are still there.
Exactly. So that's why we say, but when it was in there, I would agree with your interpretation. When the use of the people of the district was the first sentence in Section 5. I would agree that it's very arguable that Halifax could not operate outside its district, but we're dealing with what happens when that language is taken out. So the first sentence reads, the district may establish, construct, operate, and maintain such hospitals, medical facilities, and other healthcare facilities, not McDonald's, as are necessary. 1. 2.
Why wouldn't necessary mean necessary to fulfill the stated public purpose?
Because that language was taken out.
But there still is a stated public purpose.
Which I'm getting to, Your Honor.
Okay.
The hospitals, the necessary hospitals, medical facilities, and other healthcare facilities and services shall be established, etc., and maintained by the district for 1, the preservation of public health, comma, 2, for the public good, comma, and 3, for the use of the public of the district.
Right, but the use of the word "and," it doesn't say "or."
That's correct.
It says "and."
We agree it means
for
and.
the use of the public of the district. So how does the public of the district, Volusia, how do they go and use something in Tokyo, or how do they go use something in, Miami?
Justice Legault, if we can stick with Florida, I can defend myself. We're not saying disjunctive. Let's be clear. And is used as a conjunctive, but a conjunctive to link 3 things. And the doctrine of the last antecedent, and this court's decision in Kashishki and State v. Baden say we pay attention to punctuation. It means something. When it's put in a statute, it means that use of the public of the district only modifies the last clause, for the use. We have to do 3 things: public health, public good, and for the use of the public of the district. Once the first sentence is changed, and once the Oxford comma is inserted into the second sentence, that has to mean something. Now, the third sentence, Chief Justice Kennedy, says maintenance, not construction, not establishment, maintenance of such hospitals, etc., and services is hereby found and declared to be a public purpose and necessary for the general welfare of the residents of the district. Why is that language in there? Because we can use our ad valorem tax revenues for that purpose. We can use our ad valorem tax revenues to fund revenue bonds for that purpose. We cannot use our ad valorem authority, and I'm going to get to the importance of that in a minute, to maintain facilities in other districts. And as a matter of fact, under the interlocal agreement and under the bond resolution, Halifax cannot use the tax revenue it generates from the residents of the district to fund the bonds or to maintain any of the facilities in other districts. So when the legislature says this is a public purpose, that means the ad valorem taxes can be used. Now, when we get to...
Let me, back to the question I started to ask. So we have a statutory context in which the legislature authorizes itself to create entities that operate within a specific jurisdiction. You are created as an entity with a specific jurisdiction. In that context, wouldn't you need a special act that specifically said, however, here we're going to allow operations somewhere else in order to trump what I think is the presumption that you have to have if you read these together, that they're going to operate within the jurisdictional boundaries created?
Justice Lawson, let me answer that by turning it around. There are any number of special
I'd rather
acts...
you ask it as answered, but if you can't...
There are any that forbid operation outside the district in so many words. If there would be no need, if that were the default rule, for the legislature to enact a statute that forbade operations in other districts. That would be useless language, and we presume the legislature doesn't enact useless statutes. So there is no default rule under the statute. The question is, what does each enabling act mean? And of course, the special acts that create the enabling acts override general law. So the question is always, at the beginning, what does the special act mean? Now, when the legislature wanted to limit Halifax, as it did on the taxing power, as an eminent domain, it said, you may only tax residents within the district. You may only exercise eminent domain within the districts. There's at least one other special enabling act that authorizes the district to use eminent domain outside of its district. So that's lawful under at least one special act. So when the legislature wanted us to do things only within the district, it said within the district only. It doesn't say that in section 5, and the only language that suggested it has been taken out. And that's why that's a fair reading of Section 5 when you read
I
it.
think Justice Kennedy's point was that there is other language that suggests it. For use of the public of the district, in the district, that language is still in there.
Your Honor, that's what I went through. You have the disjunctive use of "and," but you have the doctrine of last antecedent for the use of the public of the district. And that now has special meaning because the first sentence has been changed. Now, we also have to look
But let me ask you this. Is there some distinction between preservation of the public health for the public good and the use of the public? Are those different things?
No, they all relate to the same thing, of course they do. But the question is,
what I'm struggling with here is there's this very clear reference to the use of the public of the district. And what you're saying is under these terms earlier in that sentence, basically packed in there is implied for the use of the public outside the district, correct?
Yes, Your Honor, public health and public good outside the
I
district.
have trouble, that's just a very odd way for the legislature to go about expressing that.
I would agree with you, Your Honor, and would that it were clearer, but we have to assume that that amendment meant something. Otherwise, that amendment in 1979, taking out that language from the first sentence means nothing. It means absolutely nothing, and we can't presume it means absolutely nothing unless the legislature tells us that this change doesn't mean anything. This wasn't a recodification, this wasn't a cleanup, that happened in 1989. In 1979, the legislature deliberately took this language out of our statute and left it in others. And I believe we stand on very firm ground in saying that has to mean something. But finally, we also have Section 15 of the Enabling Act, which requires a liberal construction. And the law on statutes with liberal construction is that that means something, and it has to be construed as it has to be reasonable construction under the rule of liberal construction. If there's any doubt, then that section has to mean something as well. But I don't want to leave out the Interlocal Act because that's the second piece of our argument. And we have Section 21 as enacted in 1989 that authorizes us to avail ourselves of any powers under any other statutes. Section 163 specifically states that it's supplemental to any other powers of local government units. So we can avail ourselves of the Interlocal Act, and we did. In an interlocal arrangement with Deltona, there's no question it's for a public purpose. There's no question it's for the good of the citizens of Deltona, which is the largest city in Florida not to have its own hospital. And that's why Deltona asked Halifax to enter into this interlocal agreement. There's no limitation, there's no geographic limitation in Chapter 163, nor could there be, because we're talking about jurisdictions, the powers of two different jurisdictions. There are functional limitations, but of course the City of Deltona could build a hospital, we can build hospitals, and so the powers are coextensive as far as that goes. So even if there's any doubt as to whether we can operate under Section 5, the legislature gave us the power to invoke other statutes, which we did under the interlocal.
Am I correct that the Interlocal Agreement Act does not allow you to do things that you're not already authorized to do?
Functionally, Your Honor. It
Right.
doesn't have geographic limitations. As a matter of fact, there's a clause in, I believe it's subsection 6 of the Interlocal Act that references extraterritorial operations and says when officials and governments are operating extraterritorially, they'll have the same privileges and immunities as they would in their own jurisdiction. So it contemplates extraterritorial operations. The question is function. Is this something you can do? And the fire district...
But it's not your position that if your authorizing act said you may not operate a hospital outside the bounds of the district, that you could then, even though you can operate a hospital, that's your function, functionally, you do that, that under the Interlocal Agreement Act, you could operate a hospital outside the
Yes,
district.
Your Honor. We would agree that if there were an express prohibition, which there is not, even if there is not an express grant of authority in Section 5, there's not an express prohibition. And the legislature knows how to do that because they've done it in any number of other special acts. So if there were an express prohibition, I would agree.
Well, so but it just, I'm struggling to see where you get authority to do anything from that you don't already have in your act, other than to join with others to accomplish what your act authorizes from the Interlocal Agreement Act. I'm struggling to see how you can pull pull some authority here out of that particular hat?
Because the interlocal act expressly contemplates operations outside of your own jurisdiction. One or the other of the two entities that enters into an interlocal agreement is operating outside of its jurisdiction necessarily, by definition. And the Attorney General opinion number 8440, which we rely on, dealt with a fire district that also had no authority except on an occasional permissive basis, like to help out when something bad happened, to operate outside of its district in its enabling act. It had no authority to enter into a contract under its enabling act with another jurisdiction to provide fire services. The Attorney General found that there was no such power, but that the interlocal agreement could be invoked so that the fire district could enter into a contract with the county to provide fire services. If I'm wrong here, that's wrong. And all the fire districts and other districts that provide services outside of their territorial boundaries would be prohibited from doing so. That would unwind any number of interlocal agreements, and as the amicus brief points out, would have a very significant impact. So if there was no Section 21, for example, which the legislature expressly added to the statute, it wasn't there originally. They added Section 21, you may avail yourself of other statutes. Section 163 says that this is supplemental powers, no conflict with the special act, no conflict with the enabling act. So all else aside, the interlocal act gives us the authority to enter into a contract to build a hospital and operate a hospital in the city of Deltona. I'd like to save my remaining time for rebuttal.
I'm sorry, could I ask you one quick question?
Yes, sir.
Could you elaborate on the point that you were making about the difference between the clause that talks about establish, construct, operate, and maintain versus the next clause that just talks about maintenance of hospitals, et cetera, in the district, and why? It seems like you're putting a lot into that.
Well, Your Honor, it doesn't say that anything except maintenance within the district. Now, there it's limited. That's expressly limited. And the contrast between that sentence and the amended first sentence, and then with the carefully constructed second sentence, is we cannot use tax revenues to maintain hospitals except in the district. We agree with that. But that's why that sentence is there, because by making it a public purpose, we can use our tax revenues.
And you're asking us to infer that the legislature was basically authorizing, establishing, constructing, and operating outside the district in the clause before that, but then...
Yes, Your Honor, by taking out for the use of the people of the district from the overarching first sentence. That's when the sea change necessarily had to occur, because that language remains in several other special acts. Some that were modified at the same time, all of which were basically modified within a 5-year period, because the legislature required the codification and recodification of all special acts during a period of time in the 90s into early 2000. So that was deliberately left in other statutes and taken out of our statute. And this court's case law is very clear on the presumptive effect of that amendment. So it's all of those things read together that get us to where we should be, I believe. But again, they certainly would not prohibit us, it cannot be read as prohibiting us from entering into an interlocal agreement. Thank you.
May it please the court, Martin Goldberg on behalf of Ms. Nancy Epps. Halifax does not have the authority to build a hospital outside of its district for one simple overarching reason, and that is because the legislature has not expressly granted that authority. And I think, Chief Justice Kennedy, your observations are on point, in part because that has been the law of this court for over 100 years, that special districts are created by statute. They have no powers other than those expressly granted by the legislature, or as necessarily implied as indispensable. And this court has said, going back to 1919, that if there's any reasonable doubt about the exercise of a special district's authority, the further exercise of that authority must be arrested. And Justice Lawson, you're correct, because over 30 years, Chapter 189, when it was enacted, defined a special district as a unit of local government created for a special purpose with a limited jurisdiction geographically. And fully aware of this, as has been noted, the legislature, when it wants to authorize expressly a special district to operate extraterritorially, it knows how to do so.
I like that argument. But what do we do with the response from your opposing counsel that there are, and I think they're cited in one of the footnotes in the briefs, at least 30 other enabling acts that specifically have provisions in them which state they cannot or forbid them to act extraterritorially? Why is your opposing counsel not correct that that language would be completely unnecessary if silence, which is what we have here on the issue at best, if silence and having taken out that language is not sufficient to confer the authority?
Okay. I do not agree that there's silence. And when you
Well,
look...
okay, put out that aside. Why would you need that in the 30 enabling acts that have, you are forbidden to do something that you're already forbidden to do?
I don't think you need it.
So it's unnecessary?
It's unnecessary. I think what you
Don't we
need...
don't we have explicit law which states that we don't read things as being unnecessary?
What is necessary is for the legislature to expressly grant the authority to go outside a district. Here, in Halifax's Enabling Act, not only do you not find that express grant, but you find an express restriction.
I understand I understand what you're saying.
Yes.
And you may end up being right by what you're saying, but I do want to dig in, if it's possible, to the other point, which is that why would you need that express prohibition in multiple, again, dozens of enabling acts, where there is that provision that was cited here, subsection 6 in chapter 189, that specifically says it cannot operate extraterritorially. We don't read things as being unnecessary. The legislature does things on purpose. So if you have 3 boxes, if you have box 1 which says it's forbidden, you have box 2 which says it's authorized, and then you have box 3 where, what do I make of box 3?
Yeah. I guess the predicate is that I do not recall in this record other enabling acts as represented by my opposing counsel that specifically restrict a district from going outside its boundaries. If that is the case, even if that is the case, and it may be, it would be entirely consistent, I believe, with our position here. The absence of an express grant, or if you have an express prohibition, and I know you're looking for that article and that would assist me, I think it's consistent with our position. You have to read chapter 189 in parliamentarian with any enabling act of special law, and here they line up perfectly. And I do, contrary to my opposing counsel's argument, when it comes to the text of the Halifax Enabling Act, when you look at the words for the use of the public of the district, in the district, and for the general welfare of the residents of the district, I find that that is a restriction. We don't need it in this case, I believe, to have the decision below affirmed. Again, it comes down to the lack of an express grant. This is a policy issue that the legislature needs to make. There is a legislative framework that is in place here, and if special districts have issues with their jurisdiction, they need to go back to the legislature and ask for permission and get an amendment. And that is what has happened in the other areas. I would next want to address my colleague from Halifax's contention that removal of 9 words out of the first sentence back in 1979 makes a difference. It does not. Those very 9 words in the 1979 amendment are found in the next sentence that currently remains in the Halifax Enabling Act. And if you look back at the history, because I don't think you can use legislative history as he's trying to do to create an ambiguity in the Enabling Act. It just doesn't exist. The plain text is clear.
What else was done in the 1979 statute?
A number of things, all stylistic. And although amendments can presumptively be material, here the evidence abounds that it was stylistic. First, between 1925 and 1979, there was about 35 amendments to the Enabling Act. In 1979, those amendments were shifted into the 1979 Act. Next, a number of stylistic revisions. For example, the words empowered and authorized was turned into this more simpler may. The term said district on a number of cases.
So it was essentially it was a consolidation.
It was
measure.
Yes, and I think, and the evidence I think is clear that it was a modernization of the language in 1979.
How many hospitals, special taxing districts in Florida like this, have express grant of authority to operate outside their district?
I don't know exactly, but we have put in our brief probably 5 or 6. You have North Broward, North Brevard, Sarasota that I mentioned at the outset, but they came in and got the language both within and beyond the boundaries of the district. And we have a number of others.
Does that express grant of authority all contain the same type of language?
It's all an express grant. It doesn't use the exact word. So, for example, there is within and beyond the boundaries, outside of the boundaries. You can go into surrounding communities, but it's all an expressed, unmistakable, plain and clear grant of authority, which Halifax lacks and has lacked. Yes, Your Honor.
Do you find it ironic that if we accept Mr. Shirker's argument that those are completely irrelevant, redundant, and unnecessary? I mean, that's true, right? I mean, if a grant is not required, as the law says, then those specific grants were surplus, unnecessary.
Absolutely.
Yeah.
As if you accept Halifax's argument, a lot of other laws in the book will be unnecessary. And I want to get to that point with respect to the Interlocal Cooperation Act. And that is, first, there is nothing in the text of the ICA, which I referred to it, as that grants extraterritorial authority. There just simply isn't. My colleague refers to, in the brief, Section 2. That simply recognizes, Section 2, that various forms of local government are going to come into and may come into an interlocal agreement. But then it says in the text to exercise their powers. And whatever powers they come in with is important. And it's aspirational because then it says to cooperate and try to get the benefits of geography, population, and other factors. It doesn't say you can go out extraterritorial. And that harmonizes perfectly with Section 4, which this court, from former Justice Quince, rendered an opinion, which says plain and clear that you cannot do jointly what you cannot do separately. When you come into an interlocal agreement, you can only exercise the powers that you share in common with your contracting entity or which you can exercise separately. And here, with respect to geographic territory, that Halifax came in not having that express grant. And
I apologize. Take that one step further, or apply it to me in a typical situation. So, two cities side by side, each have individual law enforcement departments, and they enter into interlocal agreements to allow one law enforcement department to make an arrest if a suspect is fleeing or chasing, or if they see a crime being committed while on patrol in between one or the other. How would what you just said affect an interlocal agreement like that?
So that situation exactly happened. The interlocal agreement, or this act, was held when it came to police powers of adjacent communities, that if the adjacent communities were not authorized to go out extraterritorially, they had an issue. They could not contract under the ICA to extend their police powers into the next community. So the legislature stepped in, and in 1997, well after the 1969 ICA, they adopted Chapter 166-0495, which says interlocal agreements to provide law enforcement services. And that specifically allowed adjoining communities who share what he is saying, this distinction of a common function, to then operate geographically in those adjoining communities. It was enacted by the legislature. And I'll further say, in 2011, if you look at the Attorney General opinion that we cited, when another entity came back and said, can we take law enforcement and go to non-adjoining communities under the ICA, the answer was no. You need to go back and get an express grant of authority, or the legislature has to pass another law. I see that my time is up, and I will sit down. Thank you very much. We would ask that the judgment denying the bond validation be affirmed.
Thank you.
May it please the Court, Philip Havens, Assistant State Attorney, 7th Judicial Circuit of Florida. The state reserved 5 minutes of time at the conclusion of this argument that I think might have been better spent if we'd left Mr. Goldberg up here. We got involved in this case because a bond validation proceeding was initiated in the 7th Circuit. We engaged in that proceeding and found out that there was a companion case that was proceeding parallel in our courts. We I went to the attorneys who were involved in that case and got them involved, so all of the arguments that you're hearing today were presented to the trial court in the bond validation proceeding. That proceeding led us to this court on direct appeal as opposed to going through one of the appellate courts. I think the arguments have been made by both sides very well in this case. State's position is it was a very simple question that was before the trial court. It was an issue of statutory interpretation. There is language specifically in this statute that's been discussed here with both counsel that specifically says that the authority of the district is to operate within the district. The trial court relied on that language in the statute in reaching its conclusion, and the state's position here today is simply that the trial court correctly adopted the rules of statutory construction, that it relied on the specific language in this statute that created this district in reaching the conclusion, and we're here today in support of that decision by the court. Any additional time that I have, I'll give to Mr. Goldberg if he chooses to come back up.
Unless there's any other questions, we would submit it on our briefs.
Page 31 of our brief, we list all of the limited statutes, all the limited statutes.
I'm looking at it right now. I have it pulled up, footnote 20, sorry. It doesn't say forbid in any of those, does it?
It says, let me read a couple, Your Honor, with what time I have. There is created a public nonprofit authority in Baker County, Section 11, to provide quality and comprehensive care for the residents of Baker County.
Right, but doesn't forbid it.
Correct, Your Honor, but I would read that as forbidding it.
It has the similar language of for public use or use of the public that was taken out here.
No, Your Honor, not these statutes. There's a whole other set of statutes here that kept that language for the use of the public of said district when it was taken out of ours. All the statutes listed here say you may only operate within this county, within this district.
They don't forbid in other words, the language isn't we forbid you to operate extraterritorially, correct? I'm looking at footnote 20, page 31.
I understand, Your Honor. I can't read Section 7, for example, of Chapter 2005-315, which is the Lakeshore Hospital Authority. The authority is created and shall have the power to acquire, construct, improve, enlarge, repair, equip, operate, and maintain hospitals and hospital facilities in Columbia County. I read that as forbidding doing it anywhere else. And that's the language of almost all of the statutes that we cite there. And no, we don't agree that the languages that grant express authority are meaningless, not at all. The Enabling Act of each special district creates that district's powers. It is our position that although the legislature did not choose to use express language when it modified the statute in 1979, it took out language that clearly was intended to limit it and changed the punctuation in the second sentence so that the last antecedent for the use of the public district doesn't modify the first two clauses. So we believe we have a grant of authority, and we certainly believe that Section 21 of the Enabling Act has to be given meaning. It allows us to enter into an interlocal agreement, and it doesn't forbid us in Section 21 from entering into an interlocal agreement that contemplates extraterritorial operations. Thank you.
All right, we thank you all for your arguments, and that's the last case on today's docket. You may retire. The court is going to remain in session for a ceremonial event.